All right, everybody, we're going to start in a minute. A couple more people signing in here. Yeah, this works, Derek. People's alerts pop up on their computer, like, oh gosh, I got to join. So just give me a second here. Let a few more people are joining.
Yep. I'm sure right when it's at noon, everybody's going to be dialing in right now.
I can see him logging in.
Yep. And then I'll kick it off, Sam, and then I'll pass it on to you.
Perfect. Ready when you are. It's 12 o'clock.
Okay, perfect. Hey, everybody, this is Derek Carlson, CEO, broker, and owner of MVP Realty, and I'm super excited about today's Zoom training. And the reason being is that we have one of the top real estate attorneys in all of Florida with us today, and Saad. Sam has been an advocate for many of the changes that you see in these NABOR contracts, and he's going to be going over some of the 2022 NABOR contract changes. And whenever the board makes these changes, obviously with the assistance of real estate agents as well as local attorneys and their attorneys, it's important for all of you to make sure that you're ahead of the curve. The last thing you want to be doing in any industry is using an outdated contract. And I've mentioned this many times in the past. There's a reason why they made these changes. And usually those reasons are related to somebody probably filing a lawsuit against another person, right? And so they added this terminology in there to usually either make the contract more on level where both parties are equal, or to protect real estate agents, their brokerage firm, as well as the other people that are involved in the transactions. So with that said, I'd like to have Sam open this up and show you the various changes that are coming our way for the 2022 NABOR contracts. Hey, Sam.
How are you, Derek? Thank you very much. Hello, everybody. Good morning. Good afternoon. I'm excited to be able to do this with you all today. As Derek said, you know, the NABOR has the Legal Resources Committee. We draft the contracts. We update it every 2 years. It's a realtor-led committee. And the changes come from the suggestions from the NABOR realtor community. So we're really excited about all there's actually very few changes this year. It's just some important changes though. And what I'm gonna do today is I'm gonna go through them with you. The way I do these Zoom seminars, for those of you that have been on my other webinars, feel free to unmute yourself and ask your questions or type them into the chat. I'm monitoring them both. I do not have the Q&A, so just use the chat or unmute yourself. We're going to go through the changes. Now the changes, I'll tell you off the bat, the new contracts are going to be available in your forms files on NABOR.com, on Form Simplicity, on Zip Forms, all those services that you might use. They come up December 1st. So December 1st, these changes go live. You're getting a sneak peek, a preview. NABOR is going to be offering classes. You should feel free to listen to those as well. I serve as the vice chair of the committee this year, and I'm also the scribe of the committee. So I guess when you say who types this stuff, that'd be me. Sorry. The change though, we're going to dive right in, go through the sales contract, followed by some of the changes to the listing and the forms. So, all right, before I get started, does anybody have any quick questions? Seeing none, all right. So the sales contract, right off the bat on the sales contract, on the first section, we clarified that integrated home automation, which was added to the contract 2 years ago, includes the smart home components. There was always some questions about the ring doorbells, the the things you can control with your iPhone, your phone, or your iPad, those all transfer. The one thing that we tried to clarify was that, if you've got a cell phone, obviously your personal cell phone is not a part of the real property or the definition of property that's included in the contract, but the components that attach to the home do convey. The other thing that we clarified or added was that electrical vehicle charging equipment, most of which is attached to the property and is a fixture and would convey anyways, but the electric vehicle charging equipment, including all of its operational components, also conveys now. And then we added access codes in addition to keys. So if you've got, again, like one of those smart locks on your front door and it's got an access code, you need to provide the front door code when it transfers, so that hopefully the buyer will change the code and not use your old code. But all those codes need to convey at closing as well. The next section of the contract that we made adjustments to is the financing section. What we did is we made it easier to read. We did not change the substance, but we reformatted it. So now all your choices are in line along the left column. You've got your A, your B, and then down at the bottom it says seller financing is your C choice. And then you'll note here that all these lines, the boxes all line up on one line now. So that was a difference to clarify, make it easier to read in the financing section. Next change we made is the inspection section. So it used to be that you had A, B, or C. You could pick your full inspection regime, which includes the 6 inspections that the NABOR contract provides for, your systems and equipment, your radon, your mold, your permits, all those. Used to have a section that said you could just turn the regular contract into an as-is contract by checking the box, and then you wouldn't have to attach the as-is property due diligence addendum with your selection here. That seemed weird to us as a committee and to the realtors on the committee, because when you go to make your offer, typically the buyer makes an offer and they would check A, they want inspections, or C, waiver of inspections. And this B, if they were going to use B, they would just go and switch over to use the as-is contract, because that's essentially what box B did. It converted the regular contract to an as-is contract. Well, we didn't think that was necessary, and we thought it was a little bit confusing. And so since NABOR offers an as-is contract, choice B was removed. So now if you want to make an as-is offer, you use the as-is contract. The one thing that we did do for sellers is when you go in, say you're making your offer and you want inspections, but for some reason your seller wanted an as-is, we left the addendum to sales contract as is sale of property due diligence in the forms library, so that you can now counter offer with the as-is. I know a lot of sellers don't like as-is contracts, but some do, and we actually see this quite a bit in my office. So the opportunity to convert the regular NABOR sales contract to an as-is by using the addendum still exists. It just won't be an initial choice for buyers when they make their offer. The next up change is, I'd like to sing the Wizard of Oz, Ding Dong, the Witch is Dead song when I present this. The $150 penalty for failing to provide the seller's title insurance policy at long last has been removed from the contract. Now, sellers need to provide whatever title insurance policy is in their possession. So we just changed that language here. Whatever is in their possession, the seller needs to provide. And the one thing I'll caution about this, just because we have removed the penalty, if the seller has a prior policy and they don't provide it, now they're not acting in good faith and they can run into a separate problem. So be very careful about that. You don't want to have a problem just because your seller is lazy. If they've got their prior policy, they should provide it. And by the way, for sellers to provide their prior policy makes the seller's life a little easier because it clears a lot of title issues that the seller might otherwise have to deal with when we go through the closing process. So that's a good thing. Next change we made are the survey objections. So it's always been confusing to folks as to who has to have the survey when the survey is an old survey, but it wasn't certified to the seller. Could you still use it? And in consultation with the title underwriters, excuse me, consultation with the title underwriters, it was determined that most underwriters don't require a survey certified to the seller. They require a survey certified to someone in the chain of title. So if your seller received an old survey, didn't make any changes to the property, and wants to provide that survey to the new buyer, they can now do that because we removed the language which required the survey to be certified to the seller. It just needs to be provided by the seller now. We also added a new survey objection. The survey objection here says that the real property does not meet the applicable development standards of the local government having jurisdiction over the real property and is not otherwise deemed legally non-conforming. What does that mean? Well, for those of you that work in Old Naples, where they've got those old 33 1/3 foot wide lots, and you used to need 2 lots to make a buildable lot, and now you need 3 lots to make a buildable lot, you may want to raise a survey objection if you've got a lot that's too small to build on under the current code. So we made that as now a possible survey objection. Anybody have any questions about all that? Yes, Greg. You gotta unmute yourself, Greg. Go ahead. Yes, Greg.
In Old Naples, the moorings, it's pretty common that they, buy them, tear them down and rebuild them. So if somebody buys one that's only 2 lots wide, wants to tear it down, they're gonna take it out of the grandfather clause or what?
Yes, it would. You can't tear down those old houses. And my understanding is the city is not letting people tear down those old houses and rebuild bigger houses on 2 lots when they need to have 3. And when I say lots, by the way, I want to make people understand, it's the old original plan of Naples, small lots. The minimum build size in Naples is 7,500 square feet now. So you are correct. You wouldn't be able to tear down a little on a non-conforming lot and rebuild. You'd have to be conforming.
They gotta leave a wall up.
Yeah, there are things that you can do to mitigate that, and your builder and construction folks should know how to do that. But you are correct in that regard.
All right, thanks.
You're welcome. Okay. The next change that we made was the seller now has a continuing obligation to disclose any insurance claims filed or to be filed for damage to the property. So it's been an issue. Obviously, we've gotten whacked a couple of times in the last few years by hurricanes. And if the seller is going to file an insurance claim, they've got to let the buyer know so that the buyer can deal with it. And remember, in the NABOR contract, if the buyer cannot get insurance or cannot get insurance at a reasonable rate, then the buyer is going to have a right to terminate up to the closing date. So you've got to be careful. You got to know what's going on with your insurance situation. Obviously, it's a big mess. Derek and I were just discussing that before this meeting. The insurance market in Florida is a disaster. We all know this, and we're trying to deal with it as best we can. If there are claims on the property, from the hurricanes, you can pretty much guarantee you're not going to get a new policy unless you can work through with your insurance company and figure out to get those claims closed. You know, they've got the database. They all kind of know what's going on. Okay, up next is the community investigation. Oops. So in the NABOR contract, among other things, the buyer is responsible to know the community that they're buying. Now, one of the things they need to look for is ambient noise levels. The airport had requested that NABOR add a whole section on airport noise, and the committee, in its wisdom, decided it was more appropriate to just say that buyers need to be aware of ambient noise that occurs in the area around the property. But you can read into this airport noise. So that's a big deal. A lot of folks, again, particularly in Old Naples, Aqua Lane, Port Royal, Royal Harbor, the areas around downtown, anything under the flight path, really, from all directions, but particularly in the city, ambient noise levels is an issue. Okay, so we did make some pretty decent changes to the seller's maintenance obligation. It's been expanded to require the seller to cure any and all documented violations by the association, and fines that are due to the association that may come after closing. So what does all this mean? So if the seller, for example, has roof tiles that are the wrong color, the driveway is the wrong color, the bushes are overgrown, there's a truck parked in the driveway when it's supposed to be in the garage. I've seen all these cases. The association may assess a violation against the seller during the time, the pendency of the contract, after the effective date. So it's prior to the closing date. The seller is responsible for those violations, and that includes post-closing fines. And what has to happen now is we need to get, and we'll go into this further when we talk about seller's costs, the instruments and expenses on my next slide. But basically, the seller is responsible to pay all association fines and cure all violations. If they cannot be done prior to closing, then there's a 200% escrow for the estimates. And that includes the daily fines if it's already been reduced to that. So your sellers need to be current with their association prior to closing, or they're going to be unhappy sellers. In addition here, we clarified this is the seller's instruments and expenses section of the contract. We added the utility estoppel fees, outstanding balances due, and FERPTA costs to the seller's obligations to pay at closing. It's always been the case that the seller paid the FERPTA costs, but now it just clarifies that they paid the reasonable fees to the buyer's attorney or closing agent for the remittance of the withheld funds. Typically, that means, and most agencies charge, $200 to $500 to prepare the 8288 forms, and get those sent into the IRS, and that's now a seller expense. It always was a seller expense, but now it's clear. The other thing we did is the seller has to assign any insurance contracts that the buyer wants to assume. This is a big deal because of flood insurance. Flood insurance policies through FEMA are assignable. Claims are not assignable. You have to be the victim of the flood to get your FEMA money. And then you can always contract a way to give that money to the buyer later, but the seller is going to get the FEMA money from the claim, but the buyer can assume the flood policy typically saves them several $1,000s in that first year till they have to go out and get their own policy the next year. Questions about any of that? Okay, seeing none. Excuse me. I just got back from Tennessee. I'm still getting over the cold weather up there. Okay. Also, notice in the contract, you may have see these changes here where association is now capitalized. I'll get to it in a minute, but we changed the definition of association in the contract to include co-ops and condos. I'll explain that in a minute, but if you see that, that's what it is. Okay, so in the NABOR contract, it's always been the case that the buyer or seller could terminate the contract up to the closing date if association approval was not received by the closing date. However, we noticed a big problem with buyers not making application to the association within the 10 days after the effective date that they were required to apply to the association. And that was causing the delay that was causing the buyer to be able to terminate on the closing date. And it was the buyer's fault because they didn't make application in a timely manner. So what we did now is we've said the buyer's right to terminate under Standard J is conditioned upon buyer timely submitting application to the association. The buyer can't terminate if they're late. They're in default and they're going to lose their deposit. So it's very important that your buyers and homeowners associations make application within 10 days of contract. The other thing that we noticed was that sellers were getting a right to terminate the contract because the association was not issuing the estoppels or the approvals because the seller was in default of their association obligations or owed money. So now sellers are going to bring themselves current at closing. We can talk to the association about that. But if the seller cannot terminate if the seller is in default of their association's documents. And we thought that was a fair solution to both sides to make sure that the parties keep their obligation to the association and timely apply. Okay. Next up, it was clear, and it was never very clear, but it was always assumed in the contract that the seller could terminate the contract and get the deposits made as liquidated damages in the case of the buyer default. But the contract never actually said seller may terminate. So we simply added the language, seller may terminate this contract and all deposits made shall be paid to the seller in the event of a buyer default. It's a small tweak, but nevertheless an important clarification. Okay, the next change.
Sam, can I just ask something?
Yes, ma'am.
To the previous one, where you said if the seller is in default, like not paying the association or whatever, is there any kind of penalty for the seller there?
It'd only be penalties associated with the association. If the association refuses to deliver the approval by the closing date because of a seller default, then the buyer can terminate and get their deposit back. That would be the remedy.
Okay, thank you.
Yes, ma'am. Okay. The next one is probably going to catch a lot of you by surprise, unless you deal with FAR contracts in your practice. No more texting notices. From now on, there's been some case law that says that even email doesn't create a contract, but no more texting back and forth with the other agent and assuming that everybody's on notice. You must deliver notices due under the contract in writing by US mail, personal delivery, electronic mail, or fax. Text messages are not proper notice. It's in bold, it's in red, it's in the contract. Now, no more texting. There's been major problems with miscommunications and other issues, and the committee followed the FAR in getting rid of texting as a means of delivering notice. So for those of you that like to text me all the time, you can still do that, but you cannot text the other agent proper notice. Okay, I mentioned the association issue. So throughout the contract and all the addenda, it always said condo, co-op, or homeowner association, and it was very hard to read and difficult to deal with. So what we did is we added a definition of association to the miscellaneous terms section, the last section of the contract. Association shall mean all homeowner associations under Chapter 720, condominium associations under Chapter 718, and cooperative associations under Chapter 719, which may have authority over the property. So just a clarification, this is not a big deal or a big change. It just adds a definition so that it's clear. Now, the next change we made to the contract is the last one I'm going to go over on the
I just-
contract. Oh, go ahead.
Just so that redefinition, does that mean also that the HOA disclosure now applies also to condos?
No. The HOA disclosure is statutory. That has nothing to do with this. All we're doing is within this contract where it used to read homeowner association / condo / co-op, all those slashes have been removed and
Okay.
replaced with the word association. This does not change your obligations with regard to HOA disclosures or condominium document disclosures. Okay, next up, I think people are going to like the next change. It clarifies, makes things a little easier. The NABOR contract, we took out the lines that had where you would type in the type of addendum. They now are going to be checkboxes. So NABOR, as you know, I see people clapping. Hi, Darlene. NABOR had the lines, now it's checkboxes. NABOR provides 80+ forms. So the forms are here. You'll be able to check the box. Notice I want to be very careful. If attached here to, see this language? Just because you check the box does not mean that the addenda to the contract that you intended to include is attached. You have to attach the addenda to your contract. The addenda has to be signed. That has not changed. So make sure that you don't just check the box and move on. You've got to know what the addenda says. So check the box and attach the addenda to the contract when you send it out for signature. Okay, that is all the changes we made to the contract. The listing agreement, you've got the just a few little things. We changed it to match the sales contract. So going back to what I was saying about instrument and expenses and association issues, all of those things were always in the listing agreement. So the listing agreements now match the sales contract. The one thing we did to protect you guys, we added a prevailing party attorney's fees provision to the listing agreement. So I know that you don't like suing your sellers. You'd rather just move on. But if you're not a bad seller and there's a problem, then the attorney's fees are now going to be available to the winner of that lawsuit. So I think that's a nice change for the realtor community. Many of you probably have dealt with some rough sellers, and now you're going to have at least have a recourse. We did add check boxes to the listing agreement. We only provide 3 addenda to the listing agreement: your limited brokerage services, your short sale, and the blank. And of course, you should not use the blank unless you have an attorney review it, and your broker, because it's the listing agreement and you're actually obligating your broker in that case. And again, if attached here too, so make sure that you actually attach the addenda that you check the box for. Okay, next up on the addenda and the disclosures, we made some minor changes to the addenda and the disclosures, not a whole bunch. I've just got a list of them here. On the backup contract, we added an advisory that the parties seek legal counsel. Take a second to talk about that. The backup contract addendum has to be used with great care. If you've got multiple backup offers and you don't specify in the backup addendum the order that they are received and what the parties that are obligated to the backup contract, you run the risk of terminating the primary contract and obligating your seller to sell the property to multiple backups at once. Obviously, that's a terrible situation. You don't want to be in that situation where your seller now has to sell the property to two different people. That can't happen. That creates a major liability to the seller. So if you are going to use the backup addendum, you need to get with your favorite closing attorney, and you need to make sure that it's clear that you're obligating the seller in order of the backup offers. On the post-closing occupancy, we made a checkbox for buyers to have access to the property for the purpose of storing personal items. We've had some issues with buyers who want to put things in the garage and whatnot after closing, but the sellers were not granting access. You can now check the box and your buyer can have access to the property for purposes of storage. Okay, the next one is the right to make the backup contract the primary. We clarified that it's subject to the MLS rules. You cannot make the property active, of course, while you have a contract pending. MLS has to stay pending. And that was always a question that frustrated a lot of people. Why isn't my property back active? I'm not done marketing it and that sort of thing. So that clarifies that the MLS rules take precedence. Next up on the election notice, we have a lot of realtors who like using that inspection election notice with as-is contracts. That's a no-no. The as-is contract does not contain provisions that tell you what happens if the seller does not complete repairs prior to closing. So when you go into your as-is contract and you need to negotiate repairs, don't use the inspection election. You need to get with your attorney and you need to draft an amendment to contract that clarifies that the seller will make repairs and what's going to happen in the event the seller does not make those repairs in time for closing. Typically, there'll be an escrow, there could be an extension, there could be a default, but you want to at least know what's going to happen. You don't want to come to the closing date, the seller hasn't completed repairs that were agreed to on the election notice, and then there's no penalty or obligation by the seller to do anything. Now the buyer's going to be in default if they don't close, and the house isn't ready for closing. So we just added an advisory that you do not want to use the inspection election notice on the as-is contract. Okay, so the old flood insurance disclosure is now just a regular insurance disclosure. For those of you that logged into the call early, you heard Derek and I talking about the disaster that is the insurance market in Florida. Well, it's not just flood insurance premiums that are on the rise, it's all insurance premiums that are on the rise. So I recommend that you protect yourself and protect your broker by using the insurance disclosure that NABOR provides to let your buyers know that insurance premiums are going up. Nothing can be done about it. You want to live in Florida, you want to be insured, you're going to pay for it. And this is just a notice to provide to your buyers of that situation. Excuse me. Next up is the new high-rise disclosure. This has not gotten a lot of press, but it's gotten some press in Florida Realtors and some other places. Florida passed some major legislation in the wake of the condo collapse over in Surfside. They passed two inspections, we'll call them. There's the structural integrity inspection and the structural integrity reserve account inspection. Basically, what has to happen now is all condominiums that are 3 stories or higher that are within 3 miles of the coast, or I'm sorry, all condos 3 stories or higher that are 30 years old or greater, and all condos 25 years old or greater within 3 miles of the coast must be inspected for a structural inspection every 10 years. They additionally have to do a reserve study and make sure that the condos have enough money to cover the cost of repairs and updates to their buildings. Obviously, we want to prevent condo collapses in every possible conceivable way because of how terrible that is. And so the legislature made these 2 new rules for condos. I'm going to tell you right now, there are a lot of questions about this statute. There's a lot of things that have to be clarified. The inspections need to be done by 2024, and I'm not being hyperbolic here, there aren't enough engineers in the United States to do all of the inspections that are going to be required under this statute in Florida because there are so many old condo buildings. So they're working through how they're going to get this done, but they are committed to doing it. My understanding is the legislature is going to tweak this legislation, but you need to be aware with your buyers buying in condos, there's going to be some special assessments. There are going to be a lot of special assessments because condo lawyers will tell you that they don't buy green bananas because they don't think about things that are much older because they're not going to be around in 20, 30, 40 years to worry about these inspections. Well, now there's specific liability for directors and association board members if they don't do these inspections and maintain their reserve accounts. We have the additional unfortunate disaster of the American property management theft. So a lot of associations are going to be charging a lot of special assessments to deal with these new requirements under Florida law. The structural integrity inspection is a 2-step process. It is an initial inspection by an engineer or architect. And if they discover problems, then the additional, more invasive inspection is going to be coming. My understanding is a lot of engineers charge on a per square foot basis. So if it's $2-3 a square foot and you've got a 100,000 square foot condo tower, do the math. It's going to be a lot of money. And there's probably not much that can be done about that other than to get these inspections done because these associations have been pretty delinquent in my understanding and my experience in maintaining their reserve accounts. And with that, that is the NABOR contract changes. Does anybody have any questions? Greg.
Sam, I do. I heard there's a couple of issues where condos associations are not even providing the F&Qs and some other things because of this exact condo issue. How are we dealing with that in that situation?
Well, if the law has not changed with regard to the condominiums associations, a statutory requirement to provide those documents, including the FAQs, and you're exactly right. They don't know what to say on them. And they still have to provide them, and buyers have an unwaivable right to terminate the contract if they don't receive those FAQs all the way up until the closing date. So you're going to have to work with your associations, and if they have questions, they need to seek with their association counsel, but those documents have to be provided. And if they're not, buyers can terminate.
Thank you.
And Greg, you had a question?
Yeah, what did I hear you say about claims? You know, if somebody claimed, damages and, the insurance company paid the claim. What does that do to their, they can't get insurance from that company again? What is that all about?
No. If there's an open claim on the property, typically the property is uninsurable until the claims is closed. And for the life of me, I cannot recall the name of the database that all the insurance companies refer to, where they put all their claims information in. Okay. This is a giant database insurance agents have access to.
So what does closed mean, Sam? What does that mean?
The claim has to be closed, paid and closed and dealt with.
All right, okay.
So what you do is to resolve that problem, you need to have a relationship with an insurance agent, and you can ask them to search the database on your properties to see if there are open claims.
Okay,
So if you're a seller and you're going to be putting your property up on the market, make sure that all of your claims from the hurricane are closed out or are in the process of being closed out so that your buyers can get new policies, either with the current company or their own company. But the new insurance policy is not going to be available until the old claim is closed.
thank you.
Yes, sir. Other questions? Anybody? All right, Derek. Oh, yes, Darlene.
I apologize for arriving a little late. Did you talk about force majeure?
No, Darlene, NABOR does not have a force majeure clause in its contract. We have a risk of loss clause, but that didn't change this time. And so we're just going over the changes. I can talk to you separately about that, but in its infinite wisdom, the committee did not decide to add a force majeure clause to the contract this go around. Other questions? All right, Derek, thank you very much. You want to wrap it up?
Sam, I appreciate you sharing your expertise with us and all that you do with the board. And to everybody, remember, Sam's a resource, one of the prominent attorneys in all of Florida. He's an expert on the contracts. I encourage you, if your clients have any questions, as he said many times, we should not be answering those. We're not attorneys. There are attorneys here locally that are willing to help your clients with these contract challenges. And so definitely keep Sam in mind for that. Sam, I appreciate you. I look forward to the link. I'll send it out to all 1,200 realtors, and we'll make sure that we're all ready for these changes. Quick question, Sam, actually, because I've been out of the loop for the last week. When are these changes implemented? They already, if I go there now.
December 1, Derek.
Okay.
December 1. They will be live. They'll be live in the forms files on Form Simplicity, Zip Forms, DocuSign, all of those on December 1st. And NABOR is going to put on additional classes.
Okay, awesome, Tim. Thank you so much.
Thank you, everybody. I'm around. You can always call or text.
See you, Sam. Thank you.
Thank you, guys.